There's no question in my mind that scope can have a major impact on the effectiveness of national implementation of the protocol. But it's important to point out the nature of regulatory measures, including the degree of bureaucratic requirements, for example, have also an important and significant impact on the effectiveness of implementation. So it's not just a question of scope alone in terms of efficiency. In many ways, the issues around scope have not changed since the CBD entered into force in 1993. And when asked, did the Nagoya Protocol clarify or confuse the scope issue, I have to say that on one hand, the question of scope was indeed clarified by the protocol. In other respects, however, adoption of the protocol has led to some confusion over scope in implementation, to be sure. It's important to recognize that there is an underlying inherent tension in the Nagoya Protocol, and this is the result of competing aims and expectations of governments negotiating the treaty at the time, as well as a function of the nature of decision-making in the CBD. Let me explain. For a good number of countries, the protocol was intended to provide for transparent ABS by establishing, to quote an African spokesperson at the time, a harmonized, comprehensive system instead of going through 193 national laws. This was a predominant view among many countries. And yet, all parties were looking to carefully guard their prerogative to make decisions and assert their sovereignty over biodiversity within their jurisdictions. So, without exception, countries were actually looking for flexibilities. The result, of course, is that the language in a number of the protocol's provisions and its terminology is quite general and imprecise in a number of cases. These are examples of what some have called creative ambiguity. ABS has never been solely about imbalance. In fact, it's largely about striking balances between equity and efficiency, between the short term and the long term, and between providers and users. In the case of scope, as long as one is clear in ABS policy, law, and regulation what is in and what is out, casting a wide and inclusive scope is theoretically quite tenable. However, the concern with a wide scope is, again, one of balance. Too wide or ambiguous a scope can lead to the effective collapse of the ABS system. Remember the goals of the protocol and the CBD. We want protection and we want utilization, if the goal is sustainable development. It's useful to view ABS in a competitive sense, where countries should be striving to generate more benefits for their genetic resources and associated traditional knowledge through efficient regulation. In terms of advice for those governments addressing the scope of ABS, let me offer the following. Built-at-home solutions are the way to go, of course. In this context, consultation with stakeholders, subnational governments, indigenous peoples, and local communities are essential. And these are the people who will be instrumental in implementing your legislation, don't forget. Perhaps the biggest hurdle in the process of establishing a working national ABS regime is awareness building, including with legislators, stakeholders, and the general public. This is a major investment, of course, but a necessary one, as many of us have discovered. Perfection is the enemy of the good. ABS can be all-encompassing. I know that in some jurisdictions, an incremental approach is difficult to follow, but a stepwise approach has its merits. Unfortunately, in my view, the race to ratify the protocol through implementing legislation has been somewhat backward. Lawyers have been at the center of the implementation frenzy, and with all due respect to the many excellent lawyers out there working on ABS, this has actually led to needless complexity and cost. ABS policy should come first. Once you've clarified the national ABS policy principles and goals, through sufficient consultation and analysis, of course, legal drafting can follow. But that has not been the case to date in a number of countries. Instead, we have the tail wagging the dog, lawyers either working on policy or working on laws in the absence of policy. This is clearly suboptimal.